marriage claim protection against cruelty by husband and in-laws. The Andhra Pradesh High Court has said yes. In Vishwanathan Krishnamurthy versus State of Andhra Pradesh, the Andhra Pradesh High Court has held that a transgender woman who got married by following Hindu rituals and customs cannot be denied protection under Section 498 of A of IPC. 498A of IPC that deals with cruelty. Let's understand the facts of this case first. So the victim in this case had a romantic relationship with the petitioner, and the petitioner was very well aware about her gender identity. Their relationship advanced, it progressed, and in January 2019, the petitioner informed her that his family members have accepted their relationship, and soon after that they got married. But the marital bliss did not last longer, and just after 2 months of living together, husband moved out of the relationship and the matrimonial house, and he cut all the contacts with her. Then later, she received threatening and vulgar messages from his number. Then after this, she informed the police and investigation was carried out. And based on the investigation, a charge sheet was filed against the petitioner, that is the husband in this case, under Section 498A of IPC and Section 4 of Dowry Prohibition Act of 1961. Then the husband filed a petition before the High Court for quashing the criminal case. He argued before the High Court that a transgender woman cannot seek protection under the said sections because only a biological woman is contemplated by these sections. To support his argument, he referred to a recent judgment from the Supreme Court from the year 2023. We all are aware of that. It's a landmark judgment in a way. That is Supriyo alias Supriya Chakrabarti versus Union of India. He argued that by pointing out the relevant paragraphs, specific paragraphs from the judgment, he argued that the Supreme Court refused to read in family laws the trans women and other queer and similar couples. And he pointed out that the Supreme Court has directed the central government to form a committee, so that something can be done, some legal changes, something can be recognized under a specific law. And the same points out that under the current legal provisions, right, there is no such protection. He also said that a trans woman is not able to bear children, and that's why she cannot be equated to biological female. Then the High Court narrowed down the entire case to two questions, one of which was whether a trans woman in heterosexual marriage seek recourse under 498A of IPC and Section 4 of Dowry Prohibition Act. The court began by emphasizing that gender identity is not limited to biological sex that is assigned at the time of birth. Then court explained few important terms to make things more clear. Cis male, that is a person who was identified as male at the time of birth, and he himself identifies to be a male. Similarly, cis female, labeled as female at the time of birth, and she also identifies as a female. Then transgender man, labeled as female but identifies as man, and similarly transgender women. Then the court referred to Nalsa versus Union of India to highlight the fact that there is a right available to every individual to self-determine gender, to self-identify gender. The court also pointed out, again by referring to Nalsa, that fundamental rights, they are also extended to transgender males and females. It was also pointed out that being for being identified as trans men or trans women, there is no need for a surgical process or a sex reassignment surgery. The court also referred to Section 2, Clause K of the Transgender Protection of Rights Act of 2019. It defines transgender in a broad way without requiring any biological process, without requiring any surgical process. Then the court referred to few other important decisions, two of them from Supreme Court, one from Madras High Court. First one was Puttaswamy versus Union of India. We all know that, a landmark judgment on right to privacy. In that case, it was held that sexual orientation and gender identity, they form part of individual's dignity, and any discrimination on these grounds will be hit by the Constitution. Then there was Navtej Singh Johar versus Union of India. In this case, the Supreme Court observed that attaching any kind of discrimination or preconceived negative notions to the trans men and women, or who are non-binary, it is against the constitutional spirit. Then there was Arun Kumar versus Inspector General of Registration from Madras High Court, in which the Madras High Court has held that the term bride in Section 5 of Hindu Marriage Act, it covers transgender women also. Now, based on all this, the High Court of Andhra Pradesh in this case rejected the contention of the petitioner, and it was held that a transgender woman in heterosexual marriage can seek protection under 498A of IPC, that is for cruelty and dowry related harassment under Prohibition of Dowry Act 1961. Right? I will show you one important paragraph from the judgment, that is para 21. Let's see it together. Very beautifully worded. See, this is para 21. The argument of the learned counsel for the petitioner that the respondent number 2, being a trans woman, cannot be regarded as a woman merely because she is incapable of biological reproduction is deeply flawed and legally impermissible. Such a narrow view of womanhood with reproduction undermines the very spirit of the Constitution, which upholds dignity, identity, and equality of all individuals. The Honorable Supreme Court in National Legal Services Authority case that we have referred to, Nalsa versus Union of India, has unequivocally recognized the rights of transgender persons, including right to self-identify their gender. Their gender to deny a trans woman the status of a woman for the purposes of 498A solely on the ground of her reproductive capacity is to perpetuate discrimination and to violate Articles 14, 15, and 21. And such a contention deserves to be rejected at the outset. Now, this case is a classic example of purposive and inclusive interpretation of the provisions. Always remember this, that the word female cannot be restricted to what we usually understood. It carries much wider connotations. And this case is particularly relevant because it is worded in very simple words, making things very clear. Do give it a read. Otherwise, what I have discussed is more than sufficient. If you like this live session, then do share, like, comment, and subscribe to the channel. And I will see you in more such sessions. Thank you very much. Have a good day and happy weekend.